Code 16. This was heard yesterday regarding freezing of bank account.
Which is the episode?
We want to inform the
Inform them.
We will inform them.
Come at 12.
It was more not from the code 16 now to the district for withdrawal.
So,
Item number 1.
so Bharat.
Leadership,
Other side to बुला के लाएंगे.
leadership another matter from code 16 serial number 2 from daily causes. This is for restoration of CMP dismissed for non-prosecution by the order of Honorable Mr. Justice Sri Chandrasekhar, which was preferred for restoration of WPC, which was
It is not assigned to me.
Your Ladyship, this is code 16 matter. Your Worship.
No, it can't be.
Your Ladyship,
कौन है आपके सीनियर जो आपको मेंशन करने में
Mr. Samavesh.
उन्हीं को बुला के लाएंगे. उनको ये प्रोसीजर भी नहीं पता है. ऐसे नहीं होता है. वो प्रॉपर्ली एलोकेटेड होता है फाइल. ऑनरेबल चीफ जस्टिस एलोकेट करते हैं तब. वैसे भी डीएफडी का तो कोई अर्जेंसी नहीं. There is no urgency in a case which has been dismissed for default.
From supplementary list for admission, item 1, contempt civil 856 of 2023.
Leadership में kindly please order dated 14/25. They have filed the college. They have filed an affidavit. और straight away कहते हैं 5 लाख के नोट रिकवरी कर लिए मेरे फादर के सैलरी से.
ये वो recovery.
Recovery, what recovery? How come a process can be initiated
Good. Next up, good.
without?
Apna super.
क्या?
That we have recovered those very amount that was paid to the petitioner when he was in the college, he was working by the college, by the fund of the college. But as per the order itself, because it has to be, it is they have that calculating all the admissible dues have to pay. So admissible dues we have
रिकवरी
paid.
का कहाँ ऑर्डर है?
Yes, ma'am.
रिकवरी का भी ऑर्डर है.
रिकवरी का कैलकुलेट करके कैलकुलेट कर देंगे और
He has expired by now.
Yes. Thereafter, this
Oh.
petition was disposed of. And
आप डेड आदमी से भी रिकवरी करते हैं.
डेट अब उनको जो पेमेंट किए थे हम कॉलेज फंड से वो से रिकवरी किए.
You paid from college.
Yes, that was paid.
The dues was paid from college fund.
Dues were paid by the when he was working. Then he was as an honorarium, but whatever amount was paid to him, and as per the order itself, register A of my support, that amount we have recovered. And
Recovered is deduction and recovery are two different things also. I can understand that you have paid him 100 rupees and there was dues of 120, so you adjust and then you pay the remaining. ये recovery कैसे होता है?
register C का जो contents of our product, register C filed by the college.
आप कॉलेज की तरफ से हैं?
Yes. Page 14 is the C.
What is the next C?
प्रमाणित किया जाता है कि लोन बड़े विभाग राज्य साल और भी अल्बर्ट टेकर कॉलेज चैनपुर के सहायक प्रोफेसर थे, उनको सरकार द्वारा अनुमोदन होने से पूर्व में कॉलेज के द्वारा भुगतान की गई राशि का गणना प्रस्तुत की जाती है.
कब का राशि है?
When he was working in the college before the recommended before he was
इसमें 10-15 लाख रुपए अमाउंट क्यों नहीं लिखे हैं?
तो हम कैलकुलेशन
कहाँ से कैलकुलेशन?
जब पूरा कैलकुलेशन चार्ट है
87 से
फर्स्ट बार रेट पिटिशन में आने के बाद मुझे पैसा मिला. मेरे फादर डिजीज फादर ड्यूरिंग हिज लाइफ टाइम ही कुडंट गेट अ पेनी.
ये जो हम रिकवर किए का हम पूरा कैलकुलेशन चार्ट नहीं होता तो हम सप्लीमेंट्री करके फाइल कर देते हैं. ये जितना उनको हम पे और ये है इसको हम
ये किसके एम्प्लॉई है?
ये
He is the employee of the government.
परमवीर अल्बर्ट टेका कॉलेज के एम्प्लॉय थे बाद में
आपको एड मिलता होगा,
aid-
aided college
हाँ,
होगा।
yes, yes.
है ना? अच्छा, आप इनको बीच में ऑनरेरियम देते रहे, we do not know on what account and how could you give him that honorarium?
वो जो कर रहे काम करते उसके बाद में उनको हम पेमेंट करते
ये क्या
जो भी
पता
कॉलेज
क्या
के फंड से आता है,
कहाँ से पैसा?
कॉलेज का फंड में जो भी पैसा आता था गवर्नमेंट से ऐड से उसी पैसे
ये किस दिन से आपके यहाँ काम, मतलब इनका अप्रूवल, अपॉइंटमेंट का अप्रूवल कब से हुआ? What is the date of approval of his appointment? What is the date of approval of his appointment? बताइए।
पार्ट 4 में उनका जो कंटेम्प्ट पिटिशन उसमें हम उसी से पार्ट 4 का कंटेम्प्ट that is stated that the father of the prisoner was appointed against third vacant post of prisoner in Paramir overtaken Memorial College and will not for the subject of article
नहीं, ये नहीं, आपका ये अवार्ड हुआ था ना लोकसभा में, उसी से चलिए। और ये पार्टी थे, जब पार्टी थे लोक अदालत ना, मतलब क्या अवार्ड है?
वो ऑर्डर है ऊपर ऊपर रखा उसको
पढ़िए, लास्ट में ऑपरेटिव कोड पढ़िए, एन अमाउंट ऑफ रुपीज,
amount of rupees 20 lakh
नहीं 67 lakhs 54,000, यहाँ से
yes the parties have wrote here to this matter in on the terms as under an amount of rupees 67 lakh 54,359 has already been paid to the concerned college and has been disbursed to the petitioners. Around 20 lakh is payable on account of arrears of pension of the deceased employee subject to final calculation and permissible deduction, which has to be paid through the concerned college, namely Paramir Agricultural College.
तो ये कहानी कहाँ से है? Honorarium payment 1987 से। From where did you get this story? You are trying to overreach the award. Explain.
इसमें जो दिया permissible deduction before he was
ये permissible deduction किसको बोलते हैं? Honorarium is a permissible deduction.
whatever amount was paid to the petitioner.
ये तो आपका लिखा ही हुआ है। You have paid 67 lakhs 54,359 has already been paid to the concerned college and has been disbursed to the petitioners. हो गया, कहानी खत्म, स्टोरी ओवर।
Yes.
उसके बाद 20 लाख रुपए और उसके बाद जो पेंशन में जो परमिसिबल डिडक्शन था, चाहे जो भी होगा, टैक्स भी लग सकता है, टैक्सेबल है नहीं है, वी डू नॉट नो, करेक्ट? बात कर फिर क्या?
इन पर हम इंस्ट्रक्शन ले लेते हैं।
इंस्ट्रक्शन का जरूरत नहीं है, कंप्लायंस का जरूरत है। अगर उनको नहीं समझ आता है तो उनको बुला लीजिए कोर्ट में, हम लोग बताते हैं ऑर्डर कैसे पढ़ते हैं।
छुट्टी की बात करें
कौन आएंगे?
जब तक छुट्टी पर तब तक देखते कंप्लायंस हो जाएगा, कम्युनिकेट करते हैं, कोशिश करें कंप्लायंस करा दें, छुट्टी की बात रखते हैं।
Leadership and no respect with respect to PF and gratuity in the Shokas claim.
ये ग्रेचुइटी का क्या हुआ?
वो तो टोटल अमाउंट 67 लाख तो जो सेटल हुआ था उसके हिसाब से पूरे दे दिए।
सेटल नहीं हुआ, वो सिर्फ ये आया था कि इतना पैसा उनको दे दिया गया है, लेकिन उसका कोई ब्रेकअप नहीं। ये जो आप उनको पेमेंट किए हैं, इसका कोई ब्रेकअप है? होगा ना, इतना ऑड फिगर है तो इसका कोई ब्रेकअप होगा आपके पास? 67 lakhs 54,359 क्या ब्रेकअप है इसका?
इसको सप्लीमेंट्री सुपर में सब पूरा डॉक्यूमेंट्स ले आते हैं जो भी हमारे पास यहाँ है, मेरे पास आ रहा है टोटल 4
Contempt Civil 856 of 2023. Counsel for the parties are present. The learned counsel for the petitioner has referred to the show cause filed by opposite party number 4, the concerned college, and has submitted that deductions has been sought to be made from the payable amount to the petitioner. Referring to certain amount paid from March 87 onwards. The learned counsel for the opposite party has submitted that the deduction is on account of the honorarium which was paid by the college from their own fund. However, this court is of the prima facie view that such deduction is not in accordance with the award passed in contempt case civil number 574 of 2020, wherein it was specifically mentioned that an amount of rupees 67,54,359 was already paid to the concerned college and which was disbursed to the petitioners, and an amount of rupees 20 lakhs, around rupees 20 lakhs is payable on account of arrears of pension of the deceased employees subject to final calculation and permissible deduction, which has to be paid to the concerned college. The learned counsel for the opposite party seeks adjournment.
Just on the petition.
Post on 13. उसका पूरा कैलकुलेशन ले लिया जो पेमेंट किया है.
Item 2, contempt civil 518 of 2025.
In the last order dated 25/4/2025, the direction was given to the opposite parties to file show cause of compliance by 8/5/2025. Means nothing has been filed.
Your Lordship, in this case, I'm praying for one more opportunity, Your Lordship.
So regarding land acquisition award payment, Your Lordship, 3 months were given in the writ petition. That also expired in March.
Why do you need time
Your Lordship, for filing affidavit, Your Lordship.
for filing affidavit or for making payment?
We are in process to comply, Your Lordship. I have talked to the respondent authorities, Your Lordship, opposite parties, Your Lordship.
So you are in the process of complying.
Your Lordship, steps were taken in process of compliance of order passed in the writ court, Your Lordship. It will take 4 weeks, Your Lordship.
To remit the amount in the account of the petitioner.
Your Lordship,
You are waiting for the petitioner to come. कितना percentage आप?
no, Your Lordship.
फिर no yes what?
Your Lordship, इसमें शो कॉज फाइल करने के लिए
Show cause नहीं, compliance report. ना आपने compliance report फाइल किया ना आपने show cause फाइल किया और आपको कुछ ही नहीं पता कि पेमेंट करने का इंटेंशन भी है कि नहीं है कि किसका वेट करना है. पूछ करके आइए कि अकाउंट पे डेबिट करने में कितना है. पूछ के आइए.
For hearing under order 41 rule 11 item 3, second appeal 242 of 2023.
This was the matter which was mentioned yesterday.
Yesterday. So, concurrent finding is there.
You are the plaintiff or the defendant? Plaintiff or the defendant?
I'm the original defendant. Suit for partition was filed and basic story, and it has been decreed, my first appeal has been dismissed. The basic story of the partition suit was, and the genealogy is not in dispute. The basic story is that there was one Jagni Kacha. It is she married twice. The plaintiffs are the sons from the first marriage, and the defendant, that means the appellant hearing, he is the son from the second marriage. from the first marriage there were 2 sons and 1 daughter, and from the second marriage there was 1 son and 2 daughters. So basic case of the plaintiff was that the property, and this is not in dispute, the property stands in the name of Jagni Kacha, who is the mother of all the parties. That means the plaintiff as well as the defendant. Now, basic case of the plaintiff was that because it was the mother's property, and therefore after her death, all the 2 plaintiffs and the defendant number 1, they would have 1/3 each. This is the basic case. But in this case, the daughters, although it was stated in the plaint itself that there was 1 daughter from the first husband and 2 daughters from the second husband, they were never included as parties to the suit, to the partition. So the trial court and the appellate court, they have decreed the suit 1/3 to each of the parties. That means to the 2 plaintiffs and to the defendant. Now, our case was that because the property was purchased by the father of the defendant number 1, that means by the second husband of Jagni Kachap. First husband died and thereafter Jagni Kachap married second time, and the second husband of the Jagni Kachap, he purchased the property in the name of Jagni, and therefore because it was property purchased by the second husband, and from second husband the defendant number 1 itself is the only son, and therefore he would have a right because the property was purchased by his father, and this was the case.
And from her first husband, whosoever the children were, they will not.
They will not. This is the our basic defense, which has been negative by both the courts below, on the ground that because the sale deed itself mentioned that the sale consideration has been, we have failed to prove that sale consideration had come from the second husband, and therefore the sale deed itself mentioned that the property, Jagni Kachap was the owner of the property, and therefore the property would be property of all the children of.
You see, if the daughters are not partying, who can object?
But
They would come to object.
no, only one thing. That because that is the reason that we have framed one substantial question of law. As your Lordship pointed out, they can object, but your Lordship, whenever the court itself from the pleading itself finds that a necessary party has not been included in a suit, then your Lordship, it has to take into account. Had it been a fact that this fact was not disclosed, then the matter would have been different. Here the plaint itself very clearly mentioned that the plaintiff, that means from the first husband there was 1 daughter, and from the second husband there were 2 daughters, and admittedly they were not included. So suit would be bad for non-joinder of necessary party. It is not a case where it is a misjoinder or here they were the necessary parties, they were not included.
Parties are not raising any objection to that effect, and we do not know what ultimately happened, whether they are dead, alive, whether at the time of filing, after the filing of the suit, what is their status. We are not aware at all.
But
If at all, if at the time of this is partition suit.
Partition.
So it's the preliminary decree, correct? So if at the time of execution or at the time of preparation of final decree, then if somebody comes and objects, then they have a right to object. For that
But
purpose,
what would happen, your Lordship? There is difference between a preliminary decree and final decree. Here, preliminary decree is attaining finality because here only the share of the parties would be decided.
They have a right to object at any point. They have a right to object, to file a separate appeal against this. They have a right to object to at the stage of execution also they can file objection. But both the parties having joined issues, having not raised any objection with regard to non-joinder of necessary party, you expect the court to take so much to.
Here, your Lordship, because if the plaint would not have disclosed all the fact, I could have understood. Here, what the trial court does, And your Lordship may see the first substantial question. First question which I have framed is para 6, page 6, your Lordship. Whether the learned appellate court erred in decreeing the plaintiff's suit for partition and absence of female descendants of Jharkhand Kachchap, particularly after holding that the suit property was absolute property of Jharkhand Kachchap, and after her death the same would devolve on her heirs in terms of Hindu succession. So once this finding was there, then and the plaintiff also disclosed that there were female descendants, then the suit was bad for non-joinder of necessity.
And the court will take suo motu cognizance of it.
Because order 1 rule 10 is there and order 1 rule 9 itself that it would not apply where the unnecessary party has not been.
They are not even a party in this proceedings.
They are not.
तो फिर अब क्या करेंगे?
But therefore,
Therefore, if they are aggrieved, they'll have their remedies. But you being a party to the suit, cannot raise such a thing.
I could not have, but your Lordship, if this would have said
We
that.
will simply say that if they are not there before us, they are not there before us. We cannot decide about their rights. Whenever you do not know, they might not be claiming. There are so many things which may happen. Maybe they are dead. Maybe that even you do not know about their whereabouts.
If the statement would have been there that they would have been made party and then all these things would have come, the matter would have been different. But without making them a party and then coming to this finding, because they were the class 1 heirs, the moment the court says that it would devolve in terms of Hindu Succession Act, then in terms of section.
Was it mentioned in the plaint or the written statement that they will not have any right because of the reason that
Yes.
they are governed by
Yes.
customary law?
This has been mentioned.
And that plea has been rejected.
That plea has been ignored on the ground that now they would be governed by Hindu succession.
Hindu succession.
Yes.
So your contention is once it is held that they are to be governed by Hindu Succession Act, then the females ought to have been made.
Absolutely. Once therefore, both things cannot go hand in hand. Now, your Lordship may see Order 1, Rule 9, which itself says that this would not apply to Order 1, Rule 9, CPCA.
Order 1
Rule 9, misjoinder and non-joinder.
Yes, please.
No suit shall be defeated by reason of the misjoinder or non-joinder of parties, and the court may in every suit deal with the matter in controversy so far as regards the right and interest of the parties actually before it, provided that nothing in this rule shall apply to non-joinder of a necessary party. So, your Lordship, here the daughters were necessary party, because the moment the court came to a finding that it was the devolution was to take place in terms of Hindu Succession Act, the daughters would be class 1 heirs, and then their non-joinder would be a fatal to the suit for partition. So in other cases,
what are the details of these daughters?
What in other cases has happened, that whenever this has actually come to the notice of the court, then the matter has been the preliminary decree has been set aside and the matter requires to be remanded to the original court for including the daughters as well.
So, they are to be now implemented according to you.
Yes.
Matter has to be remanded back.
Yes.
What are the details of these daughters?
Details of?
These daughters?
Yes, it has been mentioned in the plaint, but addresses have not been given.
You have not given the details. किसी को
But
party
it was
बनाने के लिए हम लोग क्या करें?
नहीं, हम उसको हम नहीं बोल रहे, हम बोल रहे हैं the moment the plaintiff himself says that there is one daughter from the first husband and two daughters,
So the
and
best,
he names them, then
I think that the best, in case we accept your proposal, that it has to be remanded and whatever they are governed by Hindu Succession Act, then under such circumstances, even before remanding, it is important to hear them. Because they may say that we are not interested.
they may say, but we cannot, without impleading them, we cannot take a stand because they
No,
have not.
nobody is asking you to take a stand. What I'm thinking is that before taking a step for remand, is it not necessary to give a notice?
Yes, then I'll file an application.
You file an application. I will just that
Because
is important.
Yes,
It is absolutely
Yes,
important.
yes.
After all, their rights are under question.
absolutely.
Right? Suddenly, you have become the litigant has become enlightened, right? That the rights of the sisters are also involved, only to ensure that the degree is satisfied. और तो कोई purpose नहीं है. वैसे तो नहीं होश आया कि बहनें भी हैं.
Probably my own sisters would relinquish it in my favor.
You never know. You never know. यहाँ भी कर सकती हैं. You never know. और अगर यहाँ कर लेंगी ना, कहानी खत्म हो जाएगी फिर.
ठीक है. Ultimately, whole purpose is that proper adjudication of, because other things are not in dispute.
Merely for the purposes of remand, merely on a technical ground, हम इसको फिर से कहानी शुरू करें, इसका कोई purpose नहीं. Or maybe that this can be sent for mediation also.
Yes,
Possible?
possible.
क्या करें बताइए? ये इसी का execution चल रहा है क्या?
Therefore, that was the reason that we are making.
कहाँ है execution के लिए आइए फाइल किए हैं? कहाँ है यार execution के लिए आइए? You are seeking a prayer for staying of final decree proceedings. ऐसा तो कुछ बाहर नहीं दिखता. आप इसमें आइए फाइल करिए उनको पार्टी बना.
Yes.
ठीक है. Learned Counsel for the appellant is present. The Learned Counsel for the appellant submits that the suit was filed for partition in connection with the properties standing in the name of Jagni Kashyap, who had 2 sons and 1 daughter from first husband, and 1 son and 2 daughters from second husband. The Learned Counsel submits that the daughters were not made party in the suit, as it was claimed in the suit that they are governed by customary law. However, the learned courts have given finding that the parties are governed in terms of Hindu Succession Act 1956. The Learned Counsel has further submitted that under such circumstances, the daughters were necessary party in the suit, but daughters having not been made party, the present case be admitted on substantial question of law number 1, framed at internal page 6 of the memo of opinion. However, during the course of arguments, the Learned Counsel for the appellant has submitted that the rights of the daughters are involved, and the daughters are not the appellant before this court, nor the daughters have taken any steps for earmarking their share in the property, and therefore it would be proper if they are also made party in the proceedings before the court proceeds in the matter. Yeah. He prays for some time to file interlocutory application for admission of party. The Learned Counsel has also submitted that once the daughters appear, it could be possible that the matter is resolved through mediation. Correct? कुछ कर देंगे.
Immediately after vacation we will.
आप जो डेट बोले
ठीक.
बताइए. प्रॉपर एड्रेस दे देंगे तो हम
16th or 17th, second week of
ओके
June.
पोस्ट ऑन 16th of June.
From page is for final disposal item 1, WPC 5715 of 2018 along with item 2 to 7.
In addition, kindly see the last order.
It is still pending.
Yes, your petition is still pending.
What is it? It is so far. Yes. Why is it still pending? You have not taken any steps to expedite. 2019 का appeal is pending.
We have not preferred.
Who has preferred?
Ranchi Municipal Corporation.
That
What?
is totally different issue. Our case is totally different from the issue involved in the Ranchi Municipal Corporation case. In our case, there is a commercial contract between a private party and the Dhanbad Municipal Corporation. And on this point, there is a judgment specific on this point that in private contract matters, writ will not lie. And this judgment has been taken into consideration by coordinate bench in which
What
the
is
writ
the
was dismissed.
dispute?
My case is totally different from the case of Ranchi Municipal Corporation. Here there is a private contract and I am fully covered and squarely covered with the Supreme Court judgment.
What is the nature of demand?
Lordship,
What is the nature of demand?
pursuant to the contract entered with the advertisers, we have raised demand of advertiser charge it is as per the municipal act. And they have
Is
straightway
it-
came to this
Is it
conclusion.
advertisement charge or it is advertisement tax? What is it?
Lordship, we have filed the counter affidavit explaining all this.
No, once you
And Lordship, it is a private contract between the municipal
कोई
corporation.
प्राइवेट आदमी अगर आपसे टैक्स मांगेगा तो आप क्रेडिट नहीं लाई करेगा आप ऐसा
No,
बात
no.
करते यू सी merely because it's a private contract it may have different contours also.
No, Lordship, simply that on pursuant to the contract, we have filed the counter, Lordship, may I go through the relevant part?
जब ये लास्ट डेट में जब ये एडजर्न हो रहा था ऑन द ग्राउंड ऑफ अवेटिंग द रिजल्ट ऑफ एलपीए तब आप कहाँ थे?
I was not available in the.
Very good. At that point of time, you should have objected. There is a judicial order waiting for the judgment.
As Lordship pleases.
आप उसको उनको बोल कर एक्सपीडाइट करा लीजिए, फिर आप आ जाइए. जब एक बार जब
We
judicial
are
order
not
हो
a
जाता
party,
है,
Lordship, we are not a party in that LPI in anything. It is between the RMC and the appellant.
you are also municipal corporation.
But I am Dhanbad Municipal Corporation.
तो एक ही बात है ना.
No, Lordship,
Principle
different
of law.
entity, different entity.
Different entity है principle of law तो दोनों municipality
But
को.
we are not.
You are governed by different municipal act.
No, Lordship, but we are
Same
not,
municipal
we
act.
are not a party there
That's
to
right. You are
expedite
not
the
a
case.
party. You are not a party.
Yes.
But that involves interpretation of the provision of law by which you are also governed. Correct? The same principle of law you are governed, or you are governed by another set of principles of law.
But the issue involved is totally different, Lordship. There was no agreement and here it is agreement and everything
There
has to be
also
guided
was
by the agreement.
क्या हुआ? Agreement का period खत्म हो गया?
Lordship.
Amount
Our
was not-
identical matter has already been decided in the light of the Supreme Court judgment by a coordinate bench.
Where is that identity?
Lordship,
Where is that matter? What is the case number?
case number, yes, Lordship. The case number was 6511 of 2018.
This one. This is Dhanbad Municipal Corporation.
Lordship.
What has been done?
It was dismissed, Lordship, in the light of the Supreme Court.
Now arising out of the same municipality, there is a set of petition which is dismissed.
Leadership, kindly see order dated
Order तो हमारा ही है ना, आप क्या दिखाएंगे?
leadership being council is out of station. 20% out of station.
I have no objection, Lordship.
No objection for what?
For adjournment on the ground of
For it. Okay, WPC number 5715 of 2018. The learned counsel for the petitioner refers to order dated 17/2/2025 to submit that the LP number 728 of 2019 with other analogous cases arising out of WPC number 259 of 2016 is pending before the Honorable Division Bench. The counsel for the respondents has responded Dhanbad Municipality
Lordship.
has submitted that the present case is different from the case which has been decided by this court. And matter in the present case is covered by a judgment passed by this court in WPC number 6511 of 2018. It submits that in the contractual matter, the writ petition is not meeting. The learned counsel for the petitioner seeks settlement by submitting that the arguing counsel has gone out of solutions. आपका काउंटर कहाँ है सर? कब चाहिए बताइए?
Any date, any date.
एनी डेट मतलब एनी डेट में आपके सीनियर अवेलेबल नहीं रहेंगे, इसलिए आप बताइए कब चाहिए? सोच समझ कर बताइए.
It may be kept on second week of June.
At the request of the counsel for the petitioner, the matter is directed to be listed on 16th of June. It is made clear that the case will not be adjourned merely on account of pendency of the entry. नया जजमेंट आया है, पता है कि नहीं पता? पता है कि नहीं पता? कौन सा जजमेंट?
नहीं पता.
आपके सीनियर को जरूर पता होगा, उनको बोल दीजिएगा कि हम बोल रहे थे कि नया जजमेंट आया, ठीक है? हाँ, डेट कोई दिया ना 16
Yes, Your Lordship, in this case, payment will be done within 6 weeks.
विधि
6 weeks.
आपका अकाउंट डिटेल है उनके पास?
हाँ उसके बाद सब एक बार फिर फ्रेशली हम एक बार जाके बोलेंगे कि सारा डिटेल सबमिट कर दे, सारे लीगल है फ्रेश एक बोल देंगे. ठीक, ऐसे दिया हुआ तो था ही ऑलरेडी, बट फिर से एक बार दे देंगे नेक्स्ट वीक में.
The content civil 518 of 20. The learned counsel for the parties are present. The learned counsel for the opposite party on instructions submit that admissible amount will be remitted in the account of the petitioner. और भी है लीगल हियर.
और जॉइंट अकाउंट खोलने को वो बोले थे, जॉइंट अकाउंट खोलने हैं तो वही जॉइंट अकाउंट का नंबर दे देंगे, उसी में पेमेंट हो जाएगा.
Petitioner on account of the admissible amount will be remitted within a period of 6 weeks from today. At this, the learned counsel for the petitioner has submitted that the petitioner was asked to furnish joint account, to open a joint account in the name of
all legal.
all legal heirs, which they have already opened, and the necessary details have already been furnished to the opposite party
Copy number 2.
Number 2. And he submits that there is no impediment in direct transfer of the amount. Post this case on 26th of June in the supplementary cause list. The compliance report after remitting the admissible amount should be filed by 23rd of June.
Obligation.
Item 8 from daily list, second appeal 127 of 2019.
Counsel for the appellant is absent in order to give parties in order to give one more chance, post this case on 28th of July.
Order second 9. Second appeal 133 of 2017.
number 195/2025. Notice was issued to the legal area respondent number 1. As per the office report also, 4th March 25 also. Notice has been issued by the legal area of the report number 1. Report number 1.
The notice was issued to whom? So there is no substitution with respect to respondent number 29 and 36.
Yes, but because the same was withdrawn also.
Yes, so there is no substitution petition.
In 4888 law, see, we filed the legal area of we have explained.
अरे भाई आपसे पूछ रहे हैं
उसका allow नहीं हुआ है।
तो वो तो आपने विड्रॉ कर लिया ना, तो अलाउ कैसे होगा?
हाँ, वो withdraw.
Then there is no petition for substitution of respondent number 29 and 36.
Right.
So that has to be treated as abated.
No, I am permitted to file the face.
What permitted?
Because the same was
इसीलिए तो
filed.
adjourn हुआ था.
नहीं, adjourn हुआ था, ये respondent number 1 के में आइए जो फाइल किया।
हम आपके एडवाइजर हैं क्या जो बताएंगे क्या करना है? इतना बड़ा ऑर्डर लिख दिए कि इसके इनका दोनों आप विड्रॉ कर चुके हैं.
नहीं, उसके पहले आइए भी हम लोग फाइल किए हुए जो मैंने उन्हें काइंडली से आइए नंबर 1 काइंडली से इसमें नोटिस भी हुआ था, आइए नंबर 195.
वो तो अलग है
हाँ,
195.
वो रिस्पॉन्ड नंबर 1 के लिए।
और तो उससे क्या मतलब है? रिस्पॉन्ड नंबर 1 कौन सा आइए?
आइए नंबर 195 25. नोटिस भी इशू हुआ था।
एक ही रिस्पॉन्डेंट है.
हाँ, एक ही रिस्पॉन्डेंट, उनकी वाइफ है। Although he already appeared on behalf of the respondent number 1.
Are you appearing
ये वकालत हमारी फाइल कर चुके हैं 23 में ऑलरेडी फाइल कर चुके हैं, अभी रिसीव भी कर दी नोटिस।
देखिए आइए नंबर 195 ऑफ
मेरा असिस्टेंट के लिए 2 पॉइंट्स लॉर्डशिप के नॉलेज में देना है। इनका जो रेस्पोंडेंट नंबर 1 इनकी जो सब्सिट्यूशन में फाइल किए हुए हैं ऑलरेडी कोर्ट रेजिडेंट से रिजेक्टेड है।
रिजेक्टेड
और उसको वो ऑर्डर रिकॉल भी नहीं कराए हैं और न ही सुप्रीम कोर्ट में कहीं पॉज कराए हैं।
कौन सा ऑर्डर डेटेड
सिर्फ असिस्टेंट ऑर्डर नंबर
Standing saying order number 13 also. They filed the reply also.
ऑर्डर नंबर 13 डेटेड
Dated 25/7/23 also. What is the finding of the coordinate bench condition? The same objection they have taken earlier also. After hearing this objection, also my lord was pleased to issue notice to respondent number 1 also.
25/1
Order number 25, order number 13 order 25/7/23.
हाँ यहाँ पर रेस्पॉन्ड नंबर 1
And you see para 6,
12
6 and 7 also.
ये तब दूसरे प्रोविजन में फाइल किए हैं ना। Yes, filing a different provision altogether. Substitution नहीं फाइल होगा, इन्होंने सही रूल 90
सब्स्टिट्यूशन पहले
नहीं अभी substitution
और उसमें भी वो वोटर को इनको या फिर इनको ले आया कुछ भी कराएंगे तब ऑलरेडी रिजेक्टेड है कोर्ट रेजिडेंट से।
अभी रूल 96A में फाइल आपने अपना वकालतनामा फाइल किया है ना।
Yes, doctor. 23 में फाइल कर चुके हैं.
आपने इसमें वकालतनामा फाइल किया है ना। आप अपना ऑब्जेक्शन फाइल कीजिए राइटिंग में। ये वर्बल सबमिशन क्या होता है? फाइल योर ऑब्जेक्शन इन राइटिंग।
ऑलरेडी काउंटर फाइल किया मैंने रिप्लाई
इसमें फाइल किए
हां रिप्लाई दिए इस आइए का हम रिप्लाई नहीं उनका जो 195 का हमने रिप्लाई दिए पारा 3 4 6 and 13
Now you have filed this IE under a different provision,
Yes,
Rule
ma'am.
96A.
Yes. Because the respondent number 1 lost died after passing of the judgment.
Yes.
in civil appeal.
IA number 195 of 2025. The learned counsel for the appellant submits that by the order dated 25/7/2023, this court had refused the prayer for substitution of respondent number 1 by observing that respondent number 1 could not be made party who had died on the date of presentation of the second appeal. The learned counsel for the respondent and he submits that accordingly the petition was filed under Rule 96 capital A of Jharkhand High Court Rules, read with section 22 Rule 4 and 9 of CPC. As The respondent number 1, Mohan Mehto, died on 28/12/2016 after passing of the impugned judgment and decree in civil appeal number 167 of 2006, which was passed on 23/12/2016. But he died before filing of the second appeal, that is on 4/4/2016. The learned counsel has submitted that the respondent number 1 died after passing of the decree in the civil appeal, correct?
After passing the judgment.
After passing of the judgment,
And before preparation of decree.
after filing of the judgment, after passing of the judgment in the first appeal. The decree is dated
Decree is decree signed
Sir?
21/9/16. 21/9/16.
तो वो डिग्री के बाद ही तुम्हारी डेथ हुआ 21/9/16 नहीं सिविल अपील का जजमेंट कब पास हुआ था
Sorry, I'm sorry. Decree signed on 12/1/17.
okay. The decree was signed on 12/1/17 by the first appellate court. ये झारखंड हाई कोर्ट a party to a decree or order desiring to appeal therefrom and to make legal representative of a party who died between conclusion of hearing and pronouncement of judgment. So you have here the person has died after
After the judgment. Decree was prepared in the.
तो वो तो 96A कैसे लगे 96A तो नहीं लगेगा
As per the decree, हम लोग उसमें फाइल किए सेकंड अपील. डेट पर्सन को उनको पार्टी बना because we are not aware of the death of the respondent number 1, and we were the appellant in before the court below. And respondent number 1 died. They have
आप
not.
provision of law तो बताएंगे ना under what provision of law you have filed 96A is applicable when a person dies after conclusion of argument and before passing of the judgment. What is the provision if a person dies after passing of the judgment?
Respondent number 1 also died after passing the judgment.
हाँ तो कौन सा provision में आप अप्लाई करेंगे? Tell us 96A तो नहीं अप्लाई करेगा ना कहाँ है आपका 96A?
Yes, I permit to read out the 96A. I may permit to read out the 96A. A party to a decree or order desiring to appeal therefrom and to make the legal representative of a party who died between the conclusion of hearing and pronouncement of judgment, including decree or order was made, a respondent may, if such legal representative has not been made a party to any subsequent proceeding under such decree or order, enter his name as the respondent in the memorandum of appeal if he present there with an affidavit. उसमें an affidavit हम लोग फाइल किए हुए जो फाइल देखा है annexure 1 भी.
आप annexure 1 में आधार
Yes.
provision of law आधा पढ़ के आप
Yes.
annexure 1 में पहुंच जाते हैं.
There with an
So
affidavit.
therefore here is a situation where the person dies after conclusion of argument and before pronouncement of judgment. What is the provision of law for adding a party who has died after pronouncement of judgment? तो उनके legally इसको party बनानी है. CPC में होगा ना? नहीं पता. बताइए.
इसमें आगे बोलते हैं कि present therefore an affidavit showing that he did not know before the decree or order was made that such party has died or that he had no reasonable opportunity of informing the court before such decree or order was made that such party was dead and stating that such other fact as may be necessary in support of his application.
So he died prior to judgment and decree, na?
No, he died after judgment.
But ये तो this provision is governing a situation when a person dies prior to passing of decree, and the person did not have the knowledge, or he could not make any steps.
Yes.
Because arguments was already concluded, he could not take any steps.
And after judgment he died also.
Yes. So what is the procedure when a person dies after judgment?
Rule 96 will govern because after judgment he died also.
इससे लिखा है after judgment का भी situation covered है इससे.
इसमें ये बोल and
ये तो भाई आपको जो है ना हम अंग्रेजी पढ़ना नहीं सिखा सकते हैं. क्या करते हैं आप? ये जरा देखिए who dies between conclusion of hearing and pronouncement of judgment. This is not the correct provision that you are referring. आप CPC का provision
इसमें I am relying on judgment document and see the constitutional law decide this matter also. Paragraph 35 and 36 में भी find see. Paragraph 35 and 36 तो गलती से मेरा मार्क
Para 35.
35 and 36. The award decree which were the subject matter of the challenge before the High Court in these cases viewed in the light of the above conclusion would not render them to be a joint and irreparable decree, but in a substance a mere combination of several decrees depending upon the number of claimants before the court and therefore joint and several or separate vice versa the individual or their claims concerned. Consequently, even the abatement of the appeal in the High Court in respect of one or other of the appellant cannot by itself result in the abatement of the appeal in its entirety or render it is liable to be dismissed as not duly or properly constituted or not possible to be proceeded with. The conclusion to the contrary arrived at by the High Court are liable to be and are hereby set aside that apart since we have also arrived at a conclusion that the rejection of the application by the High Court was erroneous, the order passed by
अब
the
क्या
High
पढ़
Court.
रहे हैं? What are you reading? What are you reading?
Paragraph 35 and 36.
Does it deal with a situation where the person has died after the pronouncement of judgment?
No, the Honorable Supreme Court did kindly see paragraph 36 also. A liberal view, that is rule 96 is not there also. The subject matter was not rule 96. Can you allow to read me paragraph 36 also? For all the reasons stated above, we are unable to approve the decision or the manner of the disposal given by the High Court in this case, which resulted in grave injustice to the remaining appellant in denying them of their right to have an adjudication of their claims on merit. The High Court ought to have condoned the delay as paid for, keeping in view the pendency of the main appeal on its file, adopting the liberal and reasonable approach. Liberal and reasonable approach.
कोई substitution नहीं हुआ तो liberal and it is a case where the court has already held that he cannot be substituted because he died after the pronouncement of the judgment. तो इसमें कौन सा provision लगेगा बताइए? You go through the proceeding. ऐसे नहीं करेंगे. ऐसे I will not permit.
उसका आपका विषय
The learned counsel for the appellant has submitted that उसी में continuation में that the prayer for substitution was rejected on the ground that the respondent number 1 had expired after the passing of the judgment by the first appellate court. The same does not mean that the appellant cannot invoke appropriate provision of law for bringing on record the legal years of respondent number 1 who expired after passing of the judgment and before preparation. He seeks adjournment. Maintainable तो है लेकिन exact provision of law बता देंगे तब हम इस पर अभी हमको भी नहीं आ रहा.
देखना
ये चीज़ आप अभी एक हमको अभी याद नहीं आ रहा है वो मिस्टर विशाल तिवारी ने एक ऑर्डर करवाया है आप उनसे पूछ लीजिए वो बता देंगे ठीक है. अभी रिसेंटली इस पर कुछ आर्गुमेंट हुआ था लेकिन एग्जैक्ट फैक्ट हमको याद नहीं.
मच
उनको वापस और बाकी जो डेथ हो गया है उनका क्या करें
कोर्ट के लिए
जो उनका जिनका आप विड्रॉ कर दिए हैं उसका क्या
उसके लिए हम आपकी फ्रेश एप्लीकेशन आइए फाइल करते हैं गलती से वो
you have to explain
उसमें
under what
एक्सप्लेन
circumstances. Date will be on 12th of June.
यस
Item 10, MA 252 of 2023.
Any? Mr. A report has been placed before this court. Pursuant to order dated 14th of August 2024. इसमें जो चीज़ गया था उनके पास उसके बाद सामने साइन कर दिया. However, from the report it appears that one MS Neha has not complied with the direction of this court. यही है ना? The learned registrar general is directed to seek the explanation from MS Sneha and place the matter, place the explanation before this court on 11th of
Item 11, CMP 799 of 2023.
this one. Notices have been issued on that. How much is the delay?
There is 79% respondent people permit that in who are the group of the person who are in the same address. She permit me to give the register post all that person who has covered that address.
No, I don't get it. There are 79 respondents. You have to issue notice to all.
Respondent.
You have to issue notice to all of them.
But some other kind, for an example, that is serial number.
What do you want? How can a delay be controlled without? How can the
No, notice is must.
So notice
there
has
is no
to
doubt
come.
at all.
Notice
Only I
has to come. We
want
can't
to
do
save,
it.
to save the time as also it is not possible 79% is that post. Therefore, if alternative
You
notice.
see, in a case which has been dismissed for default, it is already.
No,
There
that is
is
the corona
hardly
period.
any fate.
No,
about
corona
this.
period and more so, whatever maybe, notice will be. Or notice.
CMP number 799 of 2023 with IA number 12250 of 2025. Counsel for the petitioner is present. This petition has been filed for restoration of
The second appeal number.
second appeal number 513 of 2018, which has been dismissed for non-compliance of order passed by this court on 3/12/2020. A petition for condonation of delay has also been filed.
Yes, it is that is the corona period and more so.
Let notice be issued to the respondents in the CMP as well as on the interlocutory application, for which requisites under ordinary process be filed before this court by 10th of June.
Relatively after 18, because so many persons we have to after
50 में करिए ना
28. Chuti, after that I will not be there. Problem. So many persons we have to check. After 18, what?
by 18th of July.
By 20th of July, 18th I will come. And
जुलाई का डेट दिया जून का नहीं, कोई बात नहीं, जुलाई में करिए. You take your own time.
much of that.
By 20th of July, the applicant, the petitioner shall also place an envelope to be sent through registered cover, requisites with envelope to registered cover, so that the notices under ordinary process is sent to the concerned court through registered cover for delivery. नहीं जाता है, बहुत ज़्यादा मुश्किल होता है.
इसलिए complicated हो जाता है. That is
इसलिए
only if the
you
person-
just have to put one registered cover, and we will just put the notices in that and send it to the concerned court for delivery.
to the concerned court.
आप अपने सारा ordinary notices बना लीजिए. They put it in an envelope. उसका registered का जो भी postage होगा वो डाल दीजिए. That will go to the concerned court. And then the concerned court will deliver individual notices through ordinary process and send
Yes.
compliance.
Yes. That will be mentioned in the
It will be mentioned.
Much of it.
Post
Because
on,
that will be the
post
only
on 19th of September awaiting service.
much of it. That will be the only process we can do.
यहाँ जो ordinary process से जा रहा है notice ना, it is getting lost on the way. We are getting report that notice has not been received by the concerned. 3 महीना बाद ये report आता है.
From production list of port number 60 for press firing item 1 WPC 1696 of 2025.
My lord, in this case, I am not pressing this application. Because during the pendency of the writ application, my lord, I have already filed a land revision case number 3/24 pending before the Honorable Member Board of Revenue. But since, my lord, the board is not functioning, and due to that, I have no other option than to move before this Honorable.
So,
Now the board is functioning, my lord. I have obtained an stay order from the Honorable Member Board of Revenue.
you have filed any IE also for that?
No, my lord. For withdrawal of the case, I have not filed.
Any objection?
Board withdrawal. Board withdrawal.
WPC number 1696 of 2025. The learned counsel for the petitioner seeks permission to withdraw this writ petition. And has submitted that he has already invoked the statutory remedy before member board of revenue,
Member Board.
and he may be permitted to pursue his remedy as may be permissible. Also further, respondent has no objection to the prayer for withdrawal. Considering the submissions, this petition is permitted to be withdrawn. The withdrawal of this petition will not prejudice the case of one or the other party to avail their remedy, avail the statutory remedy as per the signed. IE closed. Also further respond. दिखा है ना आपका? No objection. You have no objection
No
for prayer for
objection.
prayer quote करना.
Item 2 for production list at WPC 1933 of 2025 along with item 3.
Improved order is at
Which record should I take?
1933.
19.
This has which has the interim relief sought for.
Yes. What is the prayer?
Prayer is for quashing of annexure 9, page 3. Page
Who are
3.
you?
I am the president and secretary of the association.
Just
There is a dispute with respect to selection of the general secretary, nothing else. So how does the entire dispute become? Kindly see that is mentioned in the order itself.
you have filed an IA in another writ petition.
I had filed, then the honorable court was of the view that since this is a separate cause of action, separate.
Any order passed?
Yes, there's an order passed on that in the corrected matter itself. And we have annexed it,
That is the
page number
corrected
25. Page number 25.
It's okay. Yes, kindly give me some background because
Well, there was a change in the constitution of the trade union, bylaws of the trade union. That by virtue of that amendment, the general secretary was removed. Once Sunil Lakra was the general secretary, he was removed,
and the petition number 2, Prashant Rao, was selected. Those facts are there in the other matter. Now the dispute was taken by Sunil Lakra to the registrar trade union regarding his removal, etc., which is a subject matter of the first writ petition. Our simple point is that there are n number of judgments of this court that the registrar has no jurisdiction so far as election, etc., are concerned in a trade union. I am told that they have already instituted a civil suit. That's the remedy.
That's the remedy.
I have no difficulty with that. Now, because of an order was passed by the registrar on 24th, kindly have a look at page 55. That will be ready. Which I believe they have wrongly quoted as 21st.
Yes. They have confirmed it also.
Sorry.
State council confirmed it.
State council
हाँ,
confirmed
ये-
it
यही
and
order
have
of-
recorded also.
Yes, that. I think this is the order he is referring to. That is in all fairness. महाशय, निर्देश अनुसार उपयुक्त विषय प्रसंगिक पत्र के संबंध में कहना है कि आपके द्वारा समर्पित संविधान संशोधन आवेदन में वे त्रुटि के उल्लेख करते हुए त्रुटि निराकरण हेतु निर्देशित किया गया था, परंतु इस संबंध में आपसे प्राप्त पत्र के माध्यम से त्रुटि निराकरण हेतु कोई दस्तावेज तथ्य उपलब्ध नहीं कराए गए। साथ ही अब तक आपसे प्राप्त आवेदन में संलग्न अनुलोमों के श्री सुनील लाकड़ा से प्राप्त शिकायत पत्र की समीक्षा से ये स्पष्ट होता है कि आपके श्रमिक संघ में वर्तमान महासचिव का चुनाव संघ में संविधान प्रावधानित नियमों का अनुरूप नहीं किया। चूंकि संघ की कार्यकारिणी एवं चुनाव नियमानुसार संपन्न नहीं है, इस प्रकार संविधान संशोधन हेतु आहूत आमसभा की कार्रवाई में संघ के संविधान के नियम 10 के अनुपालन होना भी स्पष्ट नहीं होता है। इससे प्रतीत होता है कि आपके द्वारा संविधान संशोधन में विहित नियमों का पालन नहीं किया गया है तथा आपके श्रमिक संघ के संविधान संशोधन हेतु वर्तमान में प्राप्त आवेदन को आश्रित किया है। दिस इज द सब्जेक्ट मैटर। There is no order of freezing any bank account. Now kindly come to the impugned order. With reference to the captioned subject, it is stated that due to the ongoing dispute regarding the selection of General Secretary and the order of Additional Registrar, Labour Department, Ranchi dated 21, which is 24, the above mentioned account number has been debit frozen. So the account will remain debit frozen until we receive an order from the competent court jurisdiction in this regard or a letter of settlement from the parties, that Sri Sunil Lakra and Sri Prakash Ram. It has come to our attention that Sunil Lakra has approached the Labour Department and is observed by the Additional Registrar in the order that while electing new General Secretary, the provision so and so has come.
How is concerned? How are you concerned?
It appears that there was dispute between the office bearers of the association.
We go on.
My lord, may pardon.
The only concern is Mr. Sanjeev Kumar Singh is a friend of Sunil Lakra. That's the off the record concern.
And my lord, a detailed counter affidavit in the meantime will be required.
Any private respondent here?
This
Sunil Lakra. 4-5 trade union.
no, this is state. No, registrar trade union, additional trade union, the trade unions are Ranchi. This is state.
You will file counter on behalf of 4 and 5. Thank you. WPC number 1933 of 2025. All the learned counsels appearing on behalf of the petitioners and respondent number 2 and 3 represented through Mr. Rohit Daldan Sinha and respondent number 1, 4 and 5 represented by the learned state council. Naam बताइए. Shweta Shukla, MS Shweta Shukla. This petition has been filed seeking quashing of notice dated 3/3/2025 within bracket election 9 issued by Zonal Manager Bank of India Ranchi Zone Ranchi respondent number 3, whereby the bank account of Bank of India Officers Association Jharkhand State Units being account number such and such was debit frozen. The learned counsel for the petitioner has submitted that the impugned order is contained at Annex 9 and a reference has been made to order of the additional registrar Labour Department Ranchi dated 21/2/2025, but the connected letter is dated 24/2/2025, annexed as Annexure 8 to the writ petition. He submits that it has been recorded yesterday on the submission of the learned State Council, who sought instruction yesterday itself that there is no such order dated 21/2/2025. The learned council has submitted that the nature of the order reveals that bank has tried to exceed its jurisdiction by entering into election dispute relating to the trade union. Correct?
Yes.
He has also referred to Annexure 8 and has submitted that at no point of time the said document revealed that the bank account is required to be frozen for one or the other reason. The learned counsel submits that the affairs of the petitioner has come to a grinding halt on account of freezing of the bank account. Appropriate order be passed and the petitioner be permitted to operate the bank account, subject to counter affidavit which may be filed by the respondents, and notice we also issued to private respondent number 6, at whose instance this has happened. The learned counsel for the state has confirmed that, has again confirmed today that there is no such order dated 21/2/2025, and the connected order is Annexure 8, which is dated 24/2/2025. The learned counsel for the respondent bank has also submitted that he shall seek instruction and file a counter affidavit in this case. And upon perusal of the Annexure 8 dated 24/2/2025, he is also not in a position to demonstrate as to how the impugned order freezing the bank account has been passed and how the bank is concerned with the election dispute of the petitioner. After hearing the learned counsels appearing on behalf of the parties and considering the facts and circumstances of this case, and on their perusal of the order, impugned order as contained in Annexure 9 issued by the bank freezing the bank account of the petitioner, it appears that the bank is unnecessarily entering into the dispute relating to the election or office bearer of the petitioner, and on the face of the letter it appears that the order to freeze the bank account is without any legal basis, and the same is immediately required to be stayed. Consequently, the operation, implementation and execution of Annexure 9 का details से लेंगे is stayed till the next date of hearing. Let notice be issued to the respondent number 6, for which requisites under respondent number 6 ordinary process, for which requisite under ordinary process as well as speed post be filed by the petitioner within a period of 1 week.
Yes.
1 week from today. The learned counsel for the respondent bank and state are also directed to seek instructions and file a counter affidavit in this case. Pose this case on 24th of June. 24th of June, awaiting service. Yeah, the stay will be only till 20.
Yes. Your Lakshmi will be subject to the counter session. Next matter also is staggered, so it will also come along with 26.
The connected matter we also posted on
24th of
number deadline is on 24th.
Item 12 from daily list, content civil 1095 of 2023.
Please kindly see the last order. The state of Bihar was the party in this matter. Plus the petitioner has received one letter from the department, provision department, government of Bihar, and she has been asked to provide some document regarding income certificate, Aadhaar card, PPO, copy of PPO. My client is sending within a week. She will send everything. One affidavit has to send. So let it be after vacation. In the meantime, we will send.
Content case civil number 1095 of 2023. Counsel for the petition is present. Totally appears on behalf of this. The learned counsel for the petitioner has submitted that some steps have been taken.
One letter dated 26/4/25.
And the petitioner has received the letter which is required to be complied. He seeks adjournment. Post on 18th of July. 18 July, 18 July.
Because I don't think necessary party is the Patna AG. I have got this information and the compliance is done by them.
वो कर रहे हैं.
So that they have.
That I have recorded that yes, some compliance is to be done.
I am representing 5, 4 and 5.
Respondent
The newly added.
appearance there.
Item 13 CNT 627 of 2024.
Notices were directed to be issued on the requisites time, while not exempt from the record minutes that have not received.
Yes, no?
There is no service report.
Awaiting.
Notice was submitted on
Both process था ना? दूसरा क्या? तो ordinary process था, both process था. Both process तो नहीं है, only ordinary process था. आप ध्यान दीजिए भाई, both process तो नहीं है notice. यहाँ पे both process नहीं है. Ordinary process. CMP number 627 of 2022, notices were issued pursuant to order dated 28th of March 2025, but the service report has not been received. Office is directed to send express reminder to the concerned court for sending the service report. इसमें ना बोथ नहीं है, मुझे ठीक से ऑफिस नोट बनाया है, रजिस्ट्री का नहीं है, रजिस्ट्री नहीं है।
हम सर्व करते हैं, बहुत प्रोसेस सही करते हैं, बहुत प्रोसेस सही हम करते हैं,
बहुत प्रोसेस है नहीं इसमें, ऑर्डर में नहीं। Close this case on 20th of June.
Item 14, CMP 239 of 2025.
What is this?
Sir,
What is this?
This is a CMP to recall the order passed in arbitration agreement with using 2023
Recall.
election. Very much.
Recall.
Yes, Your Worship. The prayer says recall.
Why recall?
Your Worship, part of the arbitration agreement we have challenged, Your Worship, regarding the same things. I have gone to the Supreme Court also against Your Lordship's order. That has been dismissed. Again, they have filed a review in the Supreme Court. That also has been dismissed. Now they've come here again in CMP, Your Worship.
How the CMP is maintained?
ma'am, there is a fraud. Fraud committed with me and with this court also.
What is that for?
Ma'am, in paragraph 17 of the order, it is mentioned that the respondent submitted before this honorable court that they were unaware whether they were succeeded in getting refund from cell tax or not. Whereas the cell tax department, Bokaro, under RTI reply has exposed them, stating in the RTI reply that in year 2011, 6th of May, they had respondents have received refund on the basis of 11 tax exemption forms, 63 to 73 on sale value of rupees 65 lakhs.
आपकी बात नहीं समझ आ रही।
मैडम, मैंने
आपने यहाँ के ऑर्डर के अगेंस्ट आप सुप्रीम कोर्ट गए?
सुप्रीम कोर्ट गए, लिमिटेशन के बेसिस पे मेरे को, मैं क्योंकि लेट हो गया, फादर की डेथ हो गई और मैं लेट हो गया तो इसलिए उन्होंने मेरे को केस को डिसमिस किया।
कहाँ है ऑर्डर ऑफ डिसमिस?
डिसमिसल लगा हुआ है।
पेज नंबर बताइए। उसके बाद इन्होंने रिव्यू फाइल से रिव्यू पर डिसमिसल ऑर्डर था। There is the order of dismissal of review petition.
Page 230. Ma'am, after your lordship, after that order, I got the information from sales tax department that they have done a fraud of rupees 1,30,000 with me. That is paid 233 in RTI reply.
Just a moment.
The government department is doing fraud.
Where is that RTI application?
.226, page 220.
It is dated 7th of September 2024.
Your application is 227.
Hmm?
Your application is at page number 226.
Yeah.
Correct? You were seeking information when you had already instituted review petition diary number such and such. Hold on. When did you receive it?
I received in December, page 233.
Which information are you relying upon?
Ma'am, para H,
Para?
H, page 234.
Read it please.
अपीलीय निर्णय न्याय निर्णय दिनांक 10/6/2010 के आलोक में दिनांक 6/5/2011 को पारित पुनर्निरीक्षित कर निधान संबंध में सर श्री मार्शल इंडस्ट्रीज लोहरदगा से संबंधित 11 नग प्रपत्र सी वास्ते रुपए 65,61,17 को मान्य करते हुए कर विमुक्त का दावा स्वीकार किया गया है। एंड बिफोर दैट पैरा ए जी वाणिज्य कर संयुक्त अपील धनबाद प्रमंडल धनबाद द्वारा दिनांक 10/6/2010 को पारित अपीलीय निर्णय के आलोक में दिनांक 6/5/11 को पुनर्निरीक्षित कर निर्धारण आदेश पारित किया गया है। पारित पुनर्निरीक्षण कर निर्धारण आदेश में उल्लेख किया गया है कि वर्तमान सुनवाई के क्रम में श्री मार्शल इंडस्ट्री लोहरदगा द्वारा 11 प्रपत्र नग सी वास्ते रुपये 65,117,11 का प्रस्तुत किया गया है। मैडम ये प्रूव करता है कि इनके पास पैसा आ गया। आर्बिट्रेटर का आदेश था कि इनके पास पैसा आएगा तो ये दे देंगे, वो इन्होंने नहीं किया। इनके पास पैसा 2011 में आ गया और तो इस कोर्ट में ये कहते हैं आके कि हमने पता नहीं कि हमको पैसा मिला है नहीं मिला है। ये पैरा 17 में आपने लिखा हुआ है जजमेंट में। तो मैडम ये तो फ्रॉड हुआ ना मेरे साथ। और मैंने इनसे पूछा कि इनसे मैंने पैसा भी मांगा 2000 अगस्त में कि साहब मेरे को मेरा पैसा दे दो। उन्होंने चुप रहे।
किस ऑर्डर का रिकॉल चाहिए?
मैडम 9 पॉइंट रिकॉल ऑफ 9/2023 हाई कोर्ट का ऑर्डर है।
देखिए इतना आपको पिछली बार भी बोला, मैं बड़े आराम से सुनती हूँ।
हाँ मैडम मैंने
और एकदम आराम से बोलिए।
सॉरी मैम, मेरी आवाज थोड़ी सी ज्यादा है।
एकदम आराम से बोलिए। आप जब जोर से बोलते हैं तो मेरा दिमाग चकरा जाता है।
नहीं सॉरी
ठीक से हम आपकी बात सुन रहे हैं ना, आराम से।
ठीक है
आराम से। आप हमको बताइए कि कौन से ऑर्डर का रिकॉल चाहिए?
मैडम रिकॉल है मैम 9/5/2023 को एक आपने ऑर्डर पास किया।
कौन सा पैराग्राफ में आपके साथ फ्रॉड हो गया ये बताइए?
मैडम पैरा 17 He has also submitted that out of entire claim on account of refund of sales tax amounting rupees 2,60,000, 2,60,004 rupees, only 50% was awarded so far. As the balance is concerned, it was dependent upon the success of the respondent in getting the refund from the department. He submits that he is not aware as to whether the respondents have ultimately succeeded in getting the refund from the department. But there is no legal bar for the claimant to approach the respondent with regard to balance amount. He has also submitted that the Form C was submitted on a later date and consequently the entire liability in connection with the sales tax refund cannot be fastened upon the respondent, and this finding has been recorded in the award that C form was submitted at a later date. मैं इस बारे में मेरे को यही कहना है कि इन्होंने आर्बिट्रेटर के सामने भी झूठ बोला कि फॉर्म सी लेट आया है, जबकि फॉर्म सी ये आपके पैरा 233 में पेज 233 पैरा बी
देखिए इस तरह से रिव्यू रिकॉल नहीं होता।
मैम सुप्रीम कोर्ट कहता है कि अगर कोई केस फ्रॉड किया जाए आपके इसमें केडी शर्मा
वो प्रिंसिपल सेटल्ड है कि फ्रॉड में केस सुप्रीम कोर्ट के डिसमिसल के बाद भी मेंटेनेबल।
तो मैडम ये 1,30,000 मेरे साथ फ्रॉड किया गया 2011। इनको अगर ये बता देते 2011 में कि मेरे पास पैसा आ गया है, इस कोर्ट में बता देते तो कोर्ट का ऑर्डर डिफरेंट होता।
आर्बिट्रल अवार्ड
इसमें और ये
page para 57 talks about the tax cardiology and page 49.
Page 40.
Observed that as per the award, the claimant was to claim balance 50% of rupees 2,60,004 rupees on account of sales tax from the respondent, depending upon the result of the cases filed by the respondent with the sales tax authorities. The claimant may take up the matter with the respondent for payment of the balance amount, above that is 50% of rupees 2,60,000.
CMP number 239 of 2025 for Mr. क्या नाम है आपका?
सतीश कुमार डाली।
I'm not inclined. I'm not inclined to entertain your petition. For Mr. Satish Kumar Dalmia.
मैम 1 मिनट 2 मिनट मेरी सुन लीजिए, उसके बाद आप जो करिएगा।
सुन लिए ना आपकी बात?
क्या मैंने फ्रॉड हुआ मेरे साथ 1,30,000 का फ्रॉड, मैंने इनसे पैसा मांगा, इन्होंने जवाब नहीं दिया। अब मैं कहाँ जाऊँ? अगर कोर्ट से मेरे को न्याय नहीं मिलेगा तो मेरे को कहाँ से मिलेगा? कोर्ट में आपने कहा कि आपने जजमेंट में कहा कि इनको आप अप्रोच कीजिए, ये जब ये पैसा दे नहीं रहे, ना जवाब दे रहे, तब मैं क्या करूं?
तो भाई मैं आपके एडवाइजर तो नहीं हूं ना।
नहीं एडवाइजर नहीं है मैडम, लेकिन ये तो बताएंगे ना आपकी कोर्ट से अगर न्याय नहीं मिलेगा तो कहां से मिलेगा?
कोर्ट का अलग-अलग जगह है।
कोर्ट में ये कहता है कि ये फ्रॉड कोर्ट के साथ भी किया गया। कोर्ट में इन्होंने बोला कि हमको पता नहीं है हमको पैसा मिला या नहीं मिला, और इनको पैसा मिल गया।
आप एकदम निश्चित रहिए, आप देखिए, आप ऑर्डर सुनिए। सीएमपी नंबर 239 ऑफ 2020 मिस्टर Satish Kumar Dalmia, representing is appearing in person. Counsel for the respondents is also present. This petition has been filed
सुप्रीम कोर्ट से मेरा केस रिजेक्ट हुआ लिमिटेशन के पीरियड पे, ग्राउंड पे, इस ग्राउंड पे नहीं हुआ है।
This petition has been filed for the following relief. The learned counsel for the learned counsel, the petitioner in person has submitted that the
एक बात बोल के नहीं, इन्होंने अवार्ड को भी माना नहीं है।
The arbitration appeal number 3 of 2009 was decided by this court by the order dated 9/3/2023. And the petitioner had moved before the Honorable Supreme Court against the judgment, but the Honorable Supreme Court has rejected the SLP on ground of limitation. He submits that a review petition was also filed, and which was also dismissed. The petitioner in person has submitted that during the pendency of the review petition before the Honorable Supreme Court, he has filed an application under right to information before the Joint Commissioner of Commercial Taxes, Bokaro Circle, seeking information as to when, inter alia seeking information as to when the amount was ultimately received by the respondent in connection with C form, correct? He submits that unfortunately the information could be furnished after the Honorable Supreme Court declined to entertain the review, and the present petition has been filed on seeking recall of the judgment passed by this court in arbitration appeal number 3 of 2009 on the basis of the information received under right to information. The information under right to information has been placed on record at annexure P/30, running page 230. He has in particular referred to the information furnished under column G and H. The learned counsel submits that fraud has been committed upon the petitioner, and therefore, in spite of dismissal of SLP, the present petition seeking recall is maintained. He has referred to paragraph 17 of the judgment dated 9/5/2023, passed in arbitration appeal number 3 of 2009, to submit that before this court, also before this court, the learned counsel for the respondent had submitted that he was not aware as to whether the respondents have ultimately succeeded in getting a refund from the department, although by that time the refund was already received by the department.
Madam, in year 2011, ma'am.
The petitioner in person has submitted that the refund was received as back as in the year 2011, but the respondents did not take any did not do the needful to give the amount to the petitioner, and consequently the petitioner is entitled for the amount and also interest thereon.
Ma'am, one thing is, in award of itself, it is written that if they will receive the amount, they will refund it.
The petitioner in person has also submitted that in the arbitral award dated
20th of April 2005.
20th of April 2005, it has been mentioned that it has been clearly held that the petitioner would be entitled for the amount immediately after the amount is received by the respondent.
मैम एक बात और लेनी,
बस
एक बात,
आखिरी बात,
मैडम, your global tenure, वेंचर ग्लोबल वर्सेस सत्यम कंप्यूटर, ये सुप्रीम कोर्ट ने कहा है कि अगर आर्बिट्रेटर के सामने कोई छुपाई जाए या गलत बताई जाए तो वो दैट इज ए फ्रॉड विद द आर्बिट्रेटर। इन्होंने आर्बिट्रेटर के सामने गलत बोला कि हमने सी फॉर्म लेट दिए, जबकि आपके आरटीआई रिप्लाई में इसके साबित होता है कि इन्होंने एनुअल रिटर्न लेट फाइल किया।
वैसा तो कोई ग्राउंड नहीं बनाया ना इसने.
मैंने बनाया मैम.
The learned the petitioner in person नहीं है ऐसा कोई ground.
मैम
तो
है कैसे
शांति
नहीं?
रखो ना.
मैम आई मेंशनड इट. मैम मैम इन आईए नंबर
आइए इसमें आइए भी फाइल कर दिया.
There
हाँ
are
जी.
3 IAs in lordship, that is
Double
the
3, 4,
matters
7.
under the
मैम
head
ये बाद में मालूम पड़ी.
अच्छा.
एक्चुअली क्या हुआ कि मैं कोई वकील तो हूँ.
The petitioner in person has submitted that additional ground for recall has been taken to interlocutory application filed in this case, in as much as the petitioner in as much as the respondent had also made incorrect submissions before the learned tribunal, before the arbitral tribunal.
I have mentioned in para 9, in page 9.
That is sufficient.
Ma'am, I have given it detailed chart.
सुनिए कोई बात नहीं. The learned counsel for the respondents has opposed the prayer and has submitted that the nature of relief and the grounds on which it is being prayed is not maintainable before this court. She has submitted that the petitioner is trying to reopen the entire matter in the garb of a petition seeking recall of the order. She has also submitted that the arbitration appeal was filed before this court as on in the year 2009, and the judgment itself is clear that as per the award, the claimant was to claim balance 50% of rupees 2,60,004 on account of sales tax from the respondent, depending upon the result of the cases filed by the respondent with the sales tax authorities. And it has also been held that the claimant may take up the matter with the respondent for payment of the balance amount of 50% of rupees 2,60,004. She submits that instead of availing the remedy which has been already mentioned in paragraph 57, the petitioner is trying to
Ma'am, I have
make out
availed
a case
that.
of fraud.
I have written to them. मैंने लिखा इनको.
In response, the petitioner has submitted that the petitioner has already represented before the respondent in terms of paragraph 57 of the judgment sought to be recalled, but the respondents have not yet responded, and therefore he has filed the present petition.
Yes.
After hearing the petition in person and the learned counsel appearing on behalf of the respondents, and after going through the materials which has been pointed out by the petitioner in person, this court finds that the information that the petitioner has filed this petition on the basis of certain information received from the sales tax department under right to information. In order to submit that, the amount has already been received by the respondents, but they are not giving the refund to the petitioner in terms of the award and also the order passed by this judgment passed by this court on 9/5/2023. And further, fraud is alleged by stating that it was wrongly submitted before this court that the respondents that the counsel for the respondent had no idea as to whether the refund has been, as to whether the respondents were ultimately, respondent had ultimately succeeded in getting the refund from the department or not. This court finds that numerous questions are put to the counsels who are appearing during court proceedings, and they are to respond to the court either on instructions or on the basis of materials available under law. This court finds that in paragraph 17, the counsel for the respondents had merely submitted that he was not aware as to whether the respondents have ultimately succeeded in getting the refund from the department. However, at the same time, he has also stated that there was no legal bar for the claimant to approach the respondents with regard to the balance amount. In paragraph 57, also, a clear indication was given that the claimant may take up the matter with the respondents for payment of the balance amount, that is 50% of rupees 2 lakh of rupees 2,60,004. But the petitioner is alleging fraud and fraud by not only stating that incorrect statements have been made before this court, but also by stating that incorrect statements were made before the learned arbitrator also. This court is of the view that no grounds for even prima facie observing that any fraud has been committed, and no ground for recall on the points raised by the petitioner has been made out. This court is also of the view that merely because 50% amount has not been paid to the petitioner in spite of filing representation, in terms of paragraph 57 of the order under review dated 9/5/2023, the same by itself cannot be a reason to entertain the present petition. Accordingly, this petition is hereby dismissed. However, dismissal of this petition will not be an impediment in the way of the petitioner to seek his remedies in terms of paragraph 57 of the order.
That means मैम कि ये पैसा खा देंगे.
आप किसी वकील साहब से बात करेंगे वो आपको बेहतर बताएंगे. आई एम नॉट योर एडवाइजर.
नहीं, आप एडवाइजर नहीं है मैडम. कोर्ट में मैं आया हूँ कि मेरा पैसा इनके पास बाकी है और इन्होंने दिया नहीं और ये देने की इच्छा में भी नहीं है. तो इसका मतलब कि कोर्ट ने जब ऑर्डर दिया कि आप इनको पैसा दीजिए, इनके पास इन्होंने कोर्ट से भी तो कोर्ट के सामने इन्होंने कहा कि हमको पता नहीं है. जब पता नहीं है तो इनके पास पैसा आ गया तो इनको पता नहीं है.
आपने लिखा है ना चिट्ठी उनको कि आपके पास पैसा आ गया है.
हमने तो पैसा कि हमको पैसा दीजिए.
नहीं
मैडम मैंने आरटीआई लगाई कि इन्होंने पैसा क्यों नहीं दिया, तो आरटीआई के रिप्लाई भी नहीं दिया इन्होंने. और मैंने आपके एप्लीकेशन में दिया है कि मैंने आरटीआई भी लगाई है.
अगर आपको पैसे आप यू हैव अ रेमेडी, लेकिन आई एम नॉट योर एडवाइजर. यू हैव अ रेमेडी इन लॉ, दैट मच आई कैन टेल यू, बट आई एम नॉट योर एडवाइजर. आई एम नॉट हियर टू एडवाइज यू. आई एम हियर ओनली टू पास ऑर्डर्स ऑन द पिटीशंस.
नहीं मैडम, इट इज नॉट ए फ्रॉड कि इन्होंने कोर्ट में दर्ज कहा है कि आपने हमको पैसा मिला है, नहीं हमको पता नहीं है. ये फ्रॉड इससे बढ़ के क्या होगा? अगर कोर्ट में नहीं मैडम, अगर कोर्ट में आगे कोई कोर्ट में ये सुप्रीम कोर्ट कहता है कि कोर्ट मिसरिप्रेजेंटेशन अगर कोई करता है बीजेसीआर केस में, अगर सुप्रीम कोर्ट कहता है कि कोई मिसरिप्रेजेंटेशन करता है तो यू कैन.
Item 15.
Thank you.
Please.
Yes, sir.
His Lordship Petitioner pray for quashing the order dated 5/5/2003 passed by the respondent number 2
in revision, SRA revision, and also Lordship order dated 3/6/2002, passed by the respondent number 3 uh, in SRA appeal, and also Lordship order dated 26/8/97, passed by special officer, who is the respondent number 4. In this case, Lordship, the only question whether the Chaparbandi land is under 71A, it can be 71A applicable or not. That much is the only question, Lordship. In this case, the fact of the case is, Lordship, the petitioner has purchased a land from the father of the respondent number 5 in the year 19.
Number 5.
He has not appeared, but notice has already served, Lordship. Since long he is not appearing. Though he is on file and counter affidavit and supporting the petitioner that the land in question is Chaparbandi land.
A counter affidavit has been filed to say that at no point of time you file any document to show that it was converted into Chaparbandi land.
It is, Lordship, they have not contributed the counter affidavit filed by the respondent number 5. He has already submitted here also.
Just a minute. Respondent number 5 का counter affidavit से इसलिए नहीं चलेगा. Because what we have to see is only the records.
Then, Lordship, kindly see the annexure 1. It is muted in the name of.
Annexure 1.
Yes, Lordship, page 17.
Yes.
Correction slip is there in the name of wife of the petitioner.
Correction slip.
Thereafter, Lordship, the rent receipts with the and Lordship, thereafter, Lordship, the annexure 2 is a.
No. Stick to annexure 1 first.
Yes.
Is it Chaparbandi rent receipt?
It is Chaparbandi. I have purchased the land.
Chaparbandi rent receipt is a different kind of rent receipt altogether.
No. Homestead land is always muted, and Lordship, the paddy land also muted as written that it is a paddy land. Here it is neither written paddy land.
No, Chaparbandi land receipts are different.
Lordship, kindly see the special officer's order. 1953, the father of the respondent number 5 has paid the rent. He has purchased the land 1948, and thereafter Chaparbandi land.
Rent receipt आपका कब का है?
मेरा रेंट रिसीट तो ये है 89. Thereafter it is stopped.
आपका नामांतरण वर्ष 81-82 में था, तब से छप्परबंदी माल पुजारी का भुगतान करते हैं।
उससे पहले इसका जो
अरे भाई, तो कहाँ है वो डॉक्यूमेंट? तब से छप्परबंदी 81-82 से आप छप्परबंदी रेंट रिसीट का पेमेंट करते हैं। There is a concept, a separate concept of छप्परबंदी रेंट रिसीट. It is not.
Kindly see Diva Munda, Lordship, first page. There is a fact. First page of the Lordship special officer's order, page 19, annexure 2,
yes.
page 19. हाँ, Diva Munda, plot number 82, खाता number 82, plot number स्वयंसो, रकवा स्वयंसो भूमि जिसके उसके पिता ने दीवा मुंडा से 26/5/48 को खरीद किया था। आवेदक के पिता के नामांतर हुआ, उसके द्वारा माल गुजारी का भुगतान दिया गया। वर्ष 72-73 में विपक्षी द्वारा 5 कट्ठा भूमि जयदेव मुंडा उर्फ हुसैनी मुंडा से खरीदकर छप्पर बंदी माल गुजारी की अनुमति नहीं ली गई तथा छोटनागपुर काश्तकारी अधिनियम की संख्या 41 की योग्य भूमि के वापस दिलाया गया. So this is her lordship. His petition filed by the respondent number 5. Then lordship, here it is page 20, paragraph, last paragraph. विपक्षी के विद्वान अधिवक्ता स्वयं विपक्षी के उपस्थित हो.
लास्ट ऊपर से नहीं पढ़िएगा तो कैसे लास्ट पैराग्राफ बताइए.
आगे से हम पढ़ दे रहे हैं पूरा
हाँ, पेज 19 का बॉटम पढ़िए. विपक्षी गण को विधिवत नोटिस निर्गत किया गया.
विपक्षी गण नोटिस निर्गत किया गया. काफी प्रयास के बाद विपक्षी उपस्थित होकर कारगर पूछा प्रथम प्रयोग के दाखिल किए हैं. कागज पूछा में बताया गया कि निम्नलिखित भूमि 28/11/74 को रजिस्ट्री पट्टा से हुसैनी मुंडा बल्द तुनवा मुंडा से श्रीमती सगीना देवी पत्नी जगनारायण सिंह के द्वारा खरीदा गया. खरीदे का नामांतर 81-82 में तथा तब यह छप्परबंदी मालगुजारी का भुगतान कर रहे हैं. ब्रांच दिस इज correction slip 81 annexure 1 and annexure 2.
81-82 छप्परबंदी मालगुजारी कहाँ है?
मालगुजारी लॉर्डशिप the annexure 2 page 5 page 18 page 19 and page 17 and page 18. दाखिल 16/11 खाता इतना अपना इसमें थोड़ा स्पष्ट है.
I am not able to read any one of these documents. आपने टाइप कॉपी तो फाइल किया होगा ना?
बहुत पहले फाइल किया गया, मेरे द्वारा नहीं, पीसी राय द्वारा फाइल किया गया.
तो उनको क्या एग्जेम्पशन है टाइप कॉपी फाइल करने का? एग्जेम्पशन नहीं है ना?
हम फाइल कर देते हैं टाइप कॉपी.
कहाँ है इसका टाइप?
इसका टाइप कॉपी नहीं है, लेकिन टाइप कॉपी नहीं है.
आप बताइए इनका छप्परबंदी रेंट रिसीट है. दैट इज नॉट छप्परबंदी रेंट रिसीट.
इनको प्रायर परमिशन लेना तो भी नहीं लिया. ये लेक्चर
वो ले ही लिया तो काय के लिए आते हैं
उसी ग्राउंड पे काउंटर फाइल किया गया है 30/4/2025 को. उसका
I have reply also filed by you.
इसमें तो आपके ऑर्डर में भी लिखा हुआ है that no document has been filed regarding conversion of the land into chapter.
Lordship, this is the crux of the case, that they have not taken any evidence without considering any evidence, without inquiry.
Did you read any evidence?
They have not made any inquiry.
Did you read any evidence?
Yes.
Not made any inquiry means what? आपको शोकॉस कि आपको जितना एविडेंस करना था आपको करना चाहिए.
पर्सनल इंक्वायरी, स्पेशल ऑफिसर पर्सनल इंक्वायरी भी करते हैं इसमें. That inquiry has not been made. And lordship kindly see the counter affidavit filed by the respondent number 5.
काउंटर एफिडेविट से 3 कोर्ट का ऑर्डर होने के बाद काउंटर एफिडेविट से आपका मैटर नहीं चल सकता.
Lordship, it is lordship's order. I have a judgment, lordship, that lordship has quashed.
छप्परबंदी रेंट रिसीट होगा तभी क्वेश्चन.
छप्परबंदी रेंट
वो
रिसीट
नहीं है छप्परबंदी, ऐसा नहीं है.
This is in छप्परबंदी land, lordship.
This is छप्पर होने से छप्परबंदी नहीं होता है.
He purchased, the deed then seller has been purchased.
छप्पर होने से छप्परबंदी नहीं
हर
होता है.
dwelling house था उसमें, जिस जमीन को हमने खरीदा था उसमें था, उसमें घर था.
कौन सा जजमेंट है?
Lordship, this judgment, lordship, CWJC, WPC 2009-2004 लॉर्डशिप।
फाइनल हो गया?
हाँ, इसका कोई अपील कुछ नहीं है। इसमें हुजूर दिए हैं कि जो कंपनसेशन दे के ये कर सकते हैं। पैराग्राफ 16 इफ योर लॉर्डशिप कर पैराग्राफ 19 and 21 19 20 21 this lordship that 71 second proviso also says what lordship has directed in this. And they also file an counter affidavit that they are ready to take.
What is there to show that there was construction over the property prior to coming into force of Regulation 1/1969?
That is there. That is para 3 of the counter affidavit. Counter affidavit filed by the respondent number 5. There it is. They have stated कि ये हम पहले ही कर देते और उसका रेंट रिसीट भी लगाया हुआ 1953 का रेंट रिसीट लगाया हुआ है जो कि छप्परबंदी रेंट रिसीट। Para 3. As you lot of
Respondent number 5 का counter है।
yes, para 3.
कौन फाइल किया है?
Respondent number 5.
उसका वकील कौन? You must have filed to someone. बताइए। Who was this counsel?
वकालतनामा होगा।
देखिए तो वकालतनामा है क्या? Respondent number 5 क्योंकि काउंटर एफिडेविट के साथ नहीं है, ऐसे ही विदाउट काउंटर, विदाउट वकालतनामा। होगा उनका पहले होगा सर्विस रिपोर्ट के साथ।
May I read the para 3 of that with reference to the statement made in para 5 of the petition that the respondent number 5 stated that his father purchased 55 decimal of land under khata number so-and-so, plot number so-and-so, village Pathargonda, district Ranchi, 1948. After purchase of the father of the respondent number 5, Hussaini Munda, constructed the house over the land in question. In the long use of that land as Chapparmandi, by constructing the house, the land has become Chapparmandi. The rent receipt issued by the Deed and Jamindar Chotnagpur Raja that the land was mentioned as Chapparmandi. The rent receipt dated 10/4/1953 also shows the amount of rent was fixed for the said land as Chapparmandi land.
ये जो डॉक्यूमेंट पहली बार यहाँ पे आ रहा है ना, इसका क्या ऑथेंटिसिटी है? मतलब ये डॉक्यूमेंट क्यों नहीं फाइल हुआ?
ये वहाँ भी बोला, उसका भी फाइंडिंग्स में है स्पेशल ऑफिसर का, वहाँ भी बोला है।
कहाँ है बताइए?
हम पढ़ देते हैं वो पर्टिकुलर। पेज 20 में देखा, लास्ट पैराग्राफ, पेज 20, लास्ट पैराग्राफ। आवेदन की ओर से सरकारी अधिवक्ता ने बताया कि अविवादित जमीन हस्तांतरण उद्योग की अनुमति के बिना 1974 में विपक्षी को किया गया था। कतियानी रैयत द्वारा उपरोक्त भूमि को 1948 में हुसैनी मुंडा के द्वारा हस्तांतरण किया गया था। उस समय उपरोक्त उपायुक्त के अनुमति आदिवासी के साथ हस्तांतरण की आवश्यकता नहीं थी। अतः वर्तमान आवेदक की भूमि को वापस करने का हकदार है जो खतियानी रैयत है। विपक्षी का कहना है
नहीं, एक सेकंड, ये जो ट्रांसफर 1948 में हुआ था हुसैनी मुंडा को, at that point of time it was not.
Then 19
they are questioning that transfer also, 1948 का transfer.
तो 53 का जो आज भी जो ये लेके आया है, 53 में तो छप्परबंदी उसी लैंड का है,
उसी लैंड का है जो भी है, लेकिन they are questioning the transfer of 1948 itself.
They are
जो ये ऑर्डर
उस समय जरूरत नहीं था तो ट्रांसफर कर, आदिवासी तो आदिवासी ट्रांसफर हो गया था।
आदिवासी हुसैनी मुंडा के द्वारा हस्तांतरण खतियानी रैयत द्वारा उपरोक्त भूमि को वर्ष 1948 में हुसैनी मुंडा के द्वारा स्थानांतरित किया गया था। उस समय उपायुक्त की अनुमति आदिवासी के बीच
हस्तांतरण की आवश्यकता नहीं था। वर्तमान आवेदक भूमि की वापस करने के लिए इतना
उस समय no permission was required for transfer.
That has been their findings, lordship.
लॉ से बताएंगे ना, ये तो उस समय रिक्वायरमेंट था कि नहीं परमिशन का, ये तो आप फाइंडिंग से नहीं बताएंगे ना, ये तो लॉ।
Actually lordship in this case उस समय ये परमिशन का जरूरत नहीं था इसलिए कि बिहार लैंड रेगुलेशन जो है 1969 ये एनेक्टेड हुआ है एट 68 और 69। उसके बाद उससे पहले उसका जरूरत नहीं था, उससे पहले उसको जरूरत नहीं था। द बिहार शेड्यूल एरिया रेगुलेशन रेगुलेशन 1969 that was 27 to 1974 में ये enact हुआ। तो उस समय 48 में बिहार शेड्यूल एरिया रेगुलेशन एक्ट उस समय एप्लीकेबल नहीं था। दिस नॉट एप्लीकेबल। 74 में तो ये इनैक्टमेंट में आया। ये प्रोविजन है
ऑर्डर शीट में ये आया हुआ है कि इन द ईयर और 1948 prior permission of the deputy commissioner was essential for the transfer of the tribal land. Page number 23 petition.
That is perverse. And if your lordship kindly turns to 71A second provision. Second provision. May I read that? 71A second provision. Provided further that where the deputy commissioner is satisfied that the transferee has constructed a substantial structure or building on such holding or portion thereof before coming into force of Bihar Schedule Area Regulation 1969, he may, notwithstanding any other provision of the Act, validate such transfer where the transferee either makes available to the transferor and the alternative holding or portion thereof as a case may be of the equivalent value of the vicinity or pass adequate compensation to the department determined by the commissioner for rehabilitation of the transferor. It simply says before that it is transfer. There is a building, holding is there, mutated in my name, and I am ready to compensate. They also says कि we are ready to accept the compensation. Paragraph 4 of the counter affidavit filed by the respondent, they have not controverted it by filing a counter affidavit. And otherwise also Lordship's judgment is there. Now 74 and we are in 2025. Another judgment is Lordship regarding Chopperbandi land, 71A is not applicable. Volume 3, JCR 548.
Where is the service report of this private respondent? It has been received, right?
उसका जवाब ये है प्राइवेट रिस्पोंडेंट तो हुजूर का ऑर्डर है
आपने 21/3/25 का एफिडेविट फाइल कर दिया?
लॉर्डशिप फाइल किया।
कहाँ है वो एफिडेविट?
उसमें कहीं पर भी नहीं लिखते हैं कि प्राइवेट रिस्पोंडेंट को इन लोगों जो इन्फॉर्म किया था थ्रू पुलिस, दैट हैज नॉट बीन स्टेटेड.
आपने लर्नड काउंसिल फॉर द रेस्पोंडेंट स्टेट आपने फाइल किया है। ये 24/1/25 के तहत आपने सर्विस रिपोर्ट कहाँ लगाया है?
सर्विस रिपोर्ट काउंटर रिव्यू फाइल किया गया और जो ये डायरेक्शन था
सर्विस करने का डायरेक्शन,
सर्विस करने का डायरेक्शन लॉर्ड्स इसलिए रिपोर्ट
क्यों नहीं किए? आधार के साथ सर्विस करना था ना?
रजिस्ट्रार को ये लॉर्डशिप उस दिन नहीं कोर्ट होल्ड किए थे तो रजिस्ट्रार के पास सर्विस
क्या किया?
इन्फॉर्म किया गया।
क्या इन्फॉर्म? एफिडेविट ऑफ सर्विस कहाँ है? Where is the affidavit of service? Everything does not seem right in this record. एक आदमी अपना जमीन के एफिडेविट फाइल करके गायब है। जब हम लोग कोर्ट से ऑर्डर करते हैं कि पुलिस स्टेशन के थ्रू सर्व करिए, उसका आधार लेकर यहाँ एफिडेविट ऑफ सर्विस फाइल करिए, तब आप फाइल नहीं करते। क्यों? How is it possible that the person is not interested in his land? How is it possible? झारखंड में तो लोग जान दे देगा जमीन के लिए। बताइए क्या कर देते हैं? कुछ आइडिया है आपको? यहाँ तो सारा केस कंटेस्ट होता है। ये पहला केस हम देख रहे हैं 71A का केस में रेस्पोंडेंट गायब और एफिडेविट भी फाइल किया इनका फेवर में। तो पता तो चले ना कौन है रेस्पॉन्ड नंबर 5।
सर्विस रिपोर्ट
वो बंदा आके बोल देगा आपको कॉम्पनसेशन दे दीजिए, हम सिमिलर ऑर्डर कर देंगे। आई नो हाउ टू पास इट, जितेवर का ऑर्डर कर देंगे, क्योंकि कुछ तो छप्परबंदी का दिख रहा है, लेकिन आप उनका 1948 का ही ट्रांसफर क्वेश्चन कर दें और लिख रहे हैं कि छप्परबंदी का कोई प्रूफ नहीं दिया। यहाँ तो लिख ही रहे हैं कि छप्परबंदी का इतना भुगतान कर छप्परबंदी का पेमेंट कर। आपके पास रिकॉर्ड आ गया होगा, कहाँ है रिकॉर्ड?
फाइल कर देते हैं सर्विस
रिकॉर्ड में तो होगा छप्परबंदी रेंट रिसीट पक्का।
हुजूर के पास भी है,
इसका
53 वाला हुजूर के पास भी है, और उसमें एनेक्स्चर है, वो क्या कहते हैं रिस्पोंडेंट नंबर 5 का जो काउंटर है उसमें एनेक्स्चर है।
नहीं वो तो है एनेक्स्चर उसमें, दैट आई हैव सीन।
They have not made any inquiry, they have not taken any pain for inquiry, Lordship. Simply they have passed mechanical orders.
क्या नाम है प्राइवेट रिस्पोंडेंट का?
जगन्नाथ मुंडा। नाम ये अभी आज जिंदा है कि
बाप का नाम?
बाप का नाम लेट जगदेव मुंडा एलियस हुसैनी मुंडा।
एक तो कुछ डायरेक्टली यहाँ पे सर्विस रिपोर्ट भेज दिया पुलिस को,
इसीलिए हुजूर किए थे थ्रू पीएस।
पुलिस वाला यहाँ डायरेक्टली भेज दिया, एफिडेविट नहीं कर दिया। आपके पास रिकॉर्ड है इसमें?
सिर्फ काउंटर जो फाइल किया गया,
इन्होंने जो छप्परबंदी रेंट रिसीट लगाया है प्राइवेट रिस्पोंडेंट में, इसके बारे में आपको क्या बोलना है?
तो क्लियर पता चल नहीं रहा है।
हाँ?
इसमें क्लियर पता चल नहीं रहा है क्या लिखा हुआ उसमें।
रिस्पोंडेंट नंबर 5 का है आपके पास?
ये छोटे नागपुर राज आपको छप्परबंदी में कन्वर्ट कब हुआ?
ये कन्वर्ट
1953
कन्वर्ट नहीं हुआ है। ये पारा 6 ऑफ माय काउंटर देखा जाए, पेज नंबर 7 नंबर।
वो जो ये लगाया है वो 1953 का है, डेट भी दिया है, डेटेड है 10/4/1953, रिसीट ऑफ 10/4/1993।
ये काउंटर एफिडेविट के साथ जो इन्होंने डॉक्यूमेंट लगाया एनेक्शन ए,
ये रिस्पोंडेंट नंबर 5 जो
He don't have the counter affidavit.
काउंटर एफिडेविट मेरे पास है।
आपने यहाँ पर एक सप्लीमेंट्री काउंटर एफिडेविट फाइल किया ना, आपका द ऑर्डर ऑफ कौन सा ऑर्डर था?
वो ऑर्डर डेटेड 24/1/2025, 16th ऑर्डर।
पैरा नंबर 3 में, राइट? पैरा 3 ऑफ ऑर्डर डेटेड 24/1/25 लिखे हैं इसमें, करेक्ट? उसके बाद आपने फाइल कर दिया सप्लीमेंट्री काउंटर, क्या? You have nothing to say with respect to this. आपने तो इसका कोई जवाब नहीं दाखिल किया, तो ये कुछ नहीं होने वाला। हाँ बताइए तो कौन सा ऑर्डर करना है?
लॉर्डशिप
ये वाला है ना?
यस यस
2019 देखिए तो ये ऑर्डर फाइनल हुआ कि नहीं? WPC नंबर 2019 ऑफ 2004। 24 उसके बाद तो हेल्प ही नहीं
नहीं हम भी चेक किए
लिखिए WPC number 4889 of 2003 or the learned counsel appearing on behalf of the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that as per the provisions of section 71 capital A of Chotanagpur Tenancy Act, छप्परबंदी वर्ड कहाँ यूज किया है?
किसमें
1969 के पहले का कंस्ट्रक्शन
proviso 2 if your lordship please 71A
71 yes second proviso he submits that where a substantial structure or building under holding is available prior to coming into force of Bihar Schedule Area Regulation 1969. It is open to the Deputy Commissioner to validate such transfer, where the transferee either makes available to the transferor an alternative holding or portion thereof, as the case may be, of the equivalent value of the vicinity, or pays adequate compensation to be determined by the Commissioner for rehabilitation of the transferor. The Learned Counsel has submitted that in the order passed by the SAR officer itself, by the Special Officer Schedule Area Regulation, passed under section 71 capital A of Chotanagpur Tenancy Act, itself reflected that Chaparbandi rent, that the property was already converted into Chaparbandi and the Chaparbandi rent was being paid. The Learned Counsel has submitted that all the appellate authority as well as the revisional authority have observed that no conclusive document was produced to show that the property was Chaparbandi. The Learned Counsel has referred to the counter affidavit filed by the respondent number 5 and has referred to paragraph 3 thereof, wherein he has given the entire history of the land and has also annexed a copy of rent receipt dated 10/4/1953 showing that the amount of rent was fixed for the land as Chaparbandi land. The Learned Counsel has also submitted that the private respondent has also stated in paragraph 5 that he will be satisfied if adequate compensation is given to him under second proviso of section 71 capital A of Chotanagpur Tenancy Act. The Learned Counsel has referred to the order dated 24/1/2025, wherein in paragraph 3, it has been recorded as under quote करिएगा paragraph 3 इसका. He submits that the learned counsel for the state was directed to seek instruction and file a response to the state counter affidavit filed by respondent number 5, and the affidavit was directed to be sworn by the concerned SAR officer. The learned counsel has also submitted that a supplementary counter affidavit has been filed by affidavit dated 30/4/2025, but the SAR officer has not controverted the statement and the documents made by respondent number 5. The learned counsel submits that as per the records, the fact that the property became Chaparbandi as back as in the year 1953 and rent receipt was also issued accordingly is an admitted fact. And this fact was also noticed by the SAR officer by passing the order, but
Order dated lordship.
this submission was also recorded by the SAR officer while passing the order, but still has recorded that the property was transferred in 1974 without taking permission from the Deputy Commissioner. The learned counsel has submitted that the petitioner is ready to give compensation in terms of the proviso to section 71 capital A, as has also been asserted by the private respondent. He has relied upon a judgment passed by this court in WPC number 2019 of 2004 and has submitted that in the
Para 21.
and has referred to paragraph 21 thereof, wherein the orders were set aside with the direction to the petitioner to make payment of compensation to the private respondent on the basis of कौन सा rate से देंगे?
यहाँ 1/4/2021 में दिया गया था.
2001.
2001. Here lordship, if your lordship, special officer's order may be kindly missing.
उतना दूर नहीं जाएंगे. 2001 के लिए तैयार होंगे.
तो
on the basis of the rate which was prevalent on 1/4/2001, he submits that although the transfer was made way back, but the petitioner is ready to pay compensation on the date as on 1/4/2001.
थोड़ा सा पीछे कर देते तो गरीब आदमी है वो जो ये एक 4th grade स्टाफ है.
बताइए आपका सबमिशन लिखेंगे.
On 5, 6 and 7.
The learned counsel for the respondent state has referred to paragraph 5, 6 and 7 of the
Contract.
counter affidavit dated
30 charge with the purchase.
बताइए. इतना लंबा लंबा आप लोग का एक सेंटेंस शुरू होता है 3 पेज तक चलता है. बताइए क्या बोलना है. Your one sentence runs in 3 pages.
They are only justified the special officer's order.
The learned counsel has submitted that the first transfer had taken place in the year 1948, without any permission from the Deputy Commissioner, and no document was produced to show that.
And which was not required in 1958.
1948, which was, should I record your submission? Yes. And I submitted that there is that no document was produced, and I submitted that it could not be proved by the petitioner before the authorities that the property was converted into Chapparmani. He has submitted that it has been stated in the counter affidavit that so far as conversion of railway land to Chapparmani is concerned, the petitioner did not file any document in support of this contention, and even did not disclose the date on which such conversion was made. Correct? Which was the observation made by the learned Commissioner, South Chitranagpur Division, while dismissing the revision by his order dated 5/5/2003. After hearing the learned counsel for the nobody is appearing on behalf of respondent number 5. Although a counter affidavit, as stated above, is on record, since nobody was appearing on earlier occasion also, this court by the order dated 24/1/2025 had issued notice to the respondent number 5 through the concerned police station, and the officer in charge of the concerned police station was directed to file affidavit regarding service of notice, and notice was to be served in presence of witnesses with their self-attested copy of Aadhaar card and self-attested copy of Aadhaar card of respondent number 5 was also to be taken while serving notice. This court finds that the service of notice to the respondent number 5 has been directly sent, placed on record, and the voter card of Jagannath Munda, Jainath Munda, son of Jagdev Munda, has been placed on record. This court finds that in spite of the service of notice through the concerned police station, the respondent number 5 has not appeared before this court and made any further submission, and what is available on record is only the counter affidavit filed by, on behalf of respondent number 5 is the counter affidavit filed by. After hearing the learned counsel for the petitioner and the state, and after going through the materials placed on record, this court finds that the petitioner claimed to have purchased a house over the land measuring an area of 5 kathas out of 55 decimal under Khata number 82, plot number 632, Thana number 201 in village Kathargunda, district Ranchi, in the name of his wife by registered sale deed number 17158 dated 28/11/1974 from Husaina Munda, son of Tunwa Munda, of village Kathargunda and stated that it was Chaparbandi in nature. It was also asserted that the land was purchased by the vendor through registered sale deed in the year 1948, being registered sale deed number 3808 dated 28/5/1948. After purchase, the property was also mutated in the name of the petitioner, and correction slip was also issued. The rent receipt and the correction slip, in mutation case number 733 R-27/8182 dated 16/11/81, and the rent receipt are placed on record. The specific case of the petitioner is that the petitioner had also constructed a substantial structure on the land However, the respondent number 5 had filed an application under section 71 capital A of Chotanagpur Tenancy Act. It was numbered as SAR case number 222 of 1991, seeking restoration of the land by stating that he was the legal heir of the recorded tenant and the land in question was purchased on 15/6/48 by Husaina Munda with permission of the Deputy Commissioner. The matter was the SAR officer, after granting opportunity of hearing to the parties, had passed an order dated 26/8/1997 and
restored the land.
आप देखिए पेज नंबर 20 में देखिए सीरियल नंबर 7
पेज नंबर 20
सीरियल नंबर 7
हाँ
वही डॉक्यूमेंट है जो कॉन्ट्रैक्ट
जमींदारी छप्परबंदी रिसीट
सेम है the जमींदारी
छप्परबंदी रिटर्न्स
receipt number
receipt
number
10575 10575
this is number 2496 2496 was also placed and it was submitted that the property was converted into Chaparbandi
in nature
and Chaparbandi rent was being paid, but the said document was not considered by the SAR officer by passing the order of return of the land. The appellate court as well as the judicial court observed that no prior permission of the Deputy Commissioner was taken and the appellant and the petitioner had failed to prove conclusive evidence of document issued by competent authority for conversion of Chaparbandi land. This court finds that the said document having been produced was not considered by the authorities. This court also finds that the same has been placed on record by private respondent number 5 by filing a counter affidavit. But this fact has not been controverted by the respondents, even in spite of having granted opportunity to respond to the counter affidavit filed by respondent number 5. Considering the totality of facts and circumstances, this court is of the view that the Chapparabandi was already created over the property prior to coming into force of Regulation 1 of 1969, and consequently the petitioner is entitled to same relief as was granted by this court in WPC number 2019 of 2004. The private respondent has also expressed his desire to accept the compensation as may be fixed. और बाकी उसी लाइन में
जी इसको
The petitioner has also the counsel for the petitioner has also agreed to pay compensation in terms of the rate which was prevalent as on 1/4. ठीक है, बाकी इसको इसी तरह से you have to wait for the order.
लॉर्डशिप
क्योंकि ये ना अभी डिक्टेशन देते समय हमारे नजर में वो जो सीरियल नंबर डॉक्यूमेंट फाइल हुआ था
जी
इट वाज ऑलरेडी फाइल्ड बिफोर दैट
स्पेशल ऑफिसर
वो लास्ट वाला This petition is accordingly disposed of. फैक्ट को सही से सजाना बहुत जरूरी है, नहीं तो क्या होता है कि फैक्ट में एरर होने से ऑर्डर गलत होता है,
उसके लिए
टाइम लगता है, उसके लिए हमेशा के लिए प्रॉब्लम है।